Right, welcome to the sixth hearing of the Committee's inquiry into modern slavery risks faced by temporary migrant workers in rural and regional New South Wales. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past, present, and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Dr. Joe McGurr and I am Chair of the Committee. I ask everyone in the room please to turn your mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Now, to each witness, welcome and thank you for making time to give evidence. Minister, I remind you that you do not need to be sworn as you've already sworn an oath to your office as a Member of Parliament. All other witnesses, as you've not appeared before this committee, you will need to be sworn. So could each witness, starting from my left, please state their name and position title and swear either an oath or an affirmation, perhaps starting with Dr. Casey.
Good morning, Katrina Casey, Executive Director at Safe Work New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thanks, Dr. Casey. Mr. Galvin.
Ian Galvin, I'm Director of Industrial Relations Policy in the People and Workforce Group in Premier's Department. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. And Ms. Rizzo.
Good morning. Marina Rizzo, Executive Director, Industrial Relations, Premier's Department. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you very much. Now, Minister, would you like to make an opening statement?
Thank you, Dr. McGurr and committee members. I do have a statement here, but I won't read the whole lot. What I'll just let you guys ask questions. But firstly, I'd like to acknowledge the traditional owners of the land and pay my respects to elders past, present, and emerging. Dr. McGurr and committee members, thank you very much for inviting myself and officials to your public hearing. I am very honoured, but also I want to thank you for your consideration and your passion, particularly the body of work that all of you have done, and particularly looking into modern slavery risks faced by temporary migrant workers in rural and regional New South Wales. Dr. McGurr, migrant workers are particularly vulnerable to exploitation, and we are working hard, the government is working hard to address these issues. Now, I acknowledge that the regulatory framework that applies to migrant workers at work is complex, and it is often a mix between federal and state regulators who are involved. And the employment of migrant workers is normally governed by federal legislation, while our work health and safety is governed by the Work Health and Safety Act here in New South Wales. And as you've seen, we have both our industrial relations officials and Dr. Casey from Safe Work New South Wales, and Dr. Casey and both Ms. Rizzo and Mr. Galvin will be able to provide you with the information, what we're doing in terms of collaboration, MOUs, and a range of compliance activities. There has been a number of compliance activities around Leeton, Griffith, and the Mid-North Coast, particularly in agriculture. There have been as you know, we've had past interactions with the committee have focused on labour hire and its regulation in New South Wales, but I'd just like to take some time to outline what the government is doing. While many labour hire providers in New South Wales operate responsibly and lawfully, we do know that there are the cowboys, and this is what you're examining. As this committee has heard the unscrupulous operators that seem to be most active in the horticultural and agricultural sectors, I too have received many representations from these individuals, as well as from NGOs unions and many family members, and as you have heard, it's very appalling. The evidence tells us that the triangular labour hire arrangement, where the labour hire provider is the employer while the host is not, makes it easier to shift and blur the responsibilities. Now, we know that this leads to the exploitation of workers. Regulators in other jurisdictions have approached these relationships by focusing firstly on the provider by requiring them to be licensed, and secondly on the host by requiring them to use only licensed providers. Such schemes now operate in Queensland, Victoria, South Australia and the ACT. Dr. McGurr, I'm happy to continue on, but my preference is for the committee to obviously get as much as you can out of asking us the questions.
Thank you very much, Minister, and thank you very much for appearing today and for your engagement with the committee.
Sorry, Minister, would you be prepared to table would it be helpful to table it and have that incorporated into the Hansard?
100%.
As opposed to sort of leaving it there?
Yeah, no, it's a
Because
it's
it sounds like a
I
comprehensive
thought that was going
document.
to be I thought you were intending to table that, Minister.
whatever you want me to
Yes.
do, but happy to table it and provide every member the work that we've done already. But I didn't want to, my office is prepared
Just
with our
include some
officials,
useful
so I don't
information,
want it
sure.
to go to waste. Yeah.
Yep. But I do want to explore, and we'll all have some questions, but my question really is to ask you to explore a little bit further what is happening in terms of labour hire regulation. So we have met with you before, written formally to you. It's an issue that has come up consistently in evidence to the committee that the lack of regulation is a significant issue. There seems to be widespread support both from unions, communities and from businesses to increase the regulation. I understand that the attempts at some sort of national scheme have foundered, and so very keen to hear what work's being done at state level to progress the issue of labour hire firm regulation.
Certainly, Dr. McGurr and committee members. So in 2023, New South Wales government were in a new government, and we agreed, along with all other jurisdictions, including the Commonwealth, who had made an election commitment in 2022, that they would have a harmonised labour hire regulation scheme. Now, New South Wales government was involved in ministerial meetings, and we supported a harmonised process to support and participate in the development of the National Labour Hire Licensing Scheme. A national working group expended considerable effort in developing model legislation and funding and administrative models for a national system. Dr. McGurr, following a change of government in Queensland in late 2024, Queensland government indicated that it would no longer be participating in the development of a national licensing scheme. Being involved in those meetings early on in 2023 and in 2024, there was certainly a lot of work that was happening. There was, and I think this would have come through the communique, there were not disputes, but who was going to be the host? Was it going to be Victoria or Queensland? Those two states were tasked with federal officials and their officials to work out the best process. So there was a landing, but anyway, election happened. Queensland government has said, we did not, in opposition, we did not agree with what Queensland did in terms of the labour hire scheme. However, we're happy with our scheme. We don't want to be involved in a national process. So, and that's where it ended in terms of the governments. In terms of officials continue to work to see what possible model may look like. Now, in October 2025, when we had our ministers' meeting, Queensland, the Northern Territory and Tasmania formally withdrew from the national process. So I want to report that to the committee. The remaining jurisdictions have now decided to pursue an alternate strategy of developing a set of regulatory principles that could then be realised later in harmonised legislation across all participating jurisdictions. I'm very disappointed in the collapse because we were completely invested, because for us in New South Wales, we're happy to look at other jurisdictions. They were ahead of us. I don't want to get too political, but obviously the former government here didn't set up their own system, etc. But we were willing and able. Our officials were working very hard. But anyway, here we are. Now we're exploring what a labour hire licensing scheme could look like in New South Wales, and as an interim solution, what cross-jurisdictional regulatory agreements could look like with states that have existing schemes. So we're looking at, so I can advise the committee that any New South Wales labour hire legislation would pay regard to the experience of Queensland and Victoria. In both Queensland and Victoria, substantial consultation occurred about licence fees, scheme operations and future stakeholder obligations. Now, in Victoria, as you all probably know, that Victoria Labour Hire Authority is a statutory body, whereas in Queensland, the work is done from the Office of Industrial Relations. Now, while that work is ongoing, I'm committed to taking practical actions to mitigate or close the risks faced by labour hire industry workers in New South Wales, and in the short term by utilising existing legislation and regulatory powers. So we're exploring all options. What can we do working with Queensland and Victoria, working with the feds, but in the meantime, the government, so we've Safe Work New South Wales will be able to outline, Dr. Casey will be able to outline what we're doing in terms of Safe Work New South Wales, and also industrial relations, and what are our short to medium term regulatory options at the moment. Because obviously we now have to explore what a scheme looks like here in New South Wales. I can't sit here and make a decision and say we're going to do it. It has to go through a process, an internal process for us, the government. But in the meantime, we're looking at those options, but in the meantime, we have to do something now. Mm-hmm. And so this includes a new code of practice for labour hire companies, new codes of practice for labour hire companies that are operating in New South Wales. And I also note from June this year, Safe Work codes of practice will become enforceable instruments under the new legislation that we passed last year under Work Health and Safety. Dr. McGurr and committee members, at this point in time, would you like me to refer to Dr. Casey to give you more detail about that? Or do you...
I would like some more detail. Yes, please, if we can have some
Dr.
more detail
Casey.
on how. So this is the scheme. So this is the interim solution. This is what can be done in the short term now, and you're talking about a code of conduct, code of practice for labour hire firms that will be enforceable.
We're doing this now.
Right.
This is happening now.
Okay, so perhaps some detail on that would be important.
Thanks, Minister. Thanks, Dr. McGurr. And I should say at the outset that the labour hire code of practice applies under the Work Health and Safety legislation. So I guess that's just an important context. As the Minister said, there's no separate labour hire licensing scheme. But also importantly, labour hire providers and host employers are both considered persons conducting a business or undertaking, and that means that each of those owes a primary duty of care under the Work Health and Safety legislation. So certainly any activity, compliance activity, education, awareness that Safe Work does under the Work Health and Safety Act is targeted at both labour hire companies as well as host employers. So that's just an important context. But in relation to the code of practice, the Minister has, can approve Safe Work making a code of practice in relation to lots of different activities across the Work Health and Safety legislation. Has recently approved Safe Work New South Wales to begin work on a code of practice for labour hire. There isn't a model code of practice in Australia, meaning that New South Wales will be the first one that will have this labour hire code of practice. And it will look at things like labour hire arrangements, as I said, looking at host workplaces, duties relating to the provision of adequate facilities, and we've heard lots through the different inquiries particularly the ones in Griffith and Coffs Harbour around the accommodation, amenities and issues of that consideration. So the Code of Practice can cover those sorts of things, and that's certainly the intent of the Code of Practice. When we're developing a Code of Practice, we do that in a tripartite way. So we consult with unions, with businesses, and also any experts that might help us pull together that Code of Practice. So it's very much a co-design piece of work. And the importance of that is to make sure that it's practical and it's implementable. And then, as the Minister said, the new legislation that came into place in October last year, as of July this year, Codes of Practice will be mandatory, which will then be another compliance activity that SafeWork can do on the back of the development of the Labour Hire Code of Practice.
And behind that will be SafeWork's capacity to enforce that, inspect and enforce. Is that?
Look, absolutely. And look, I wouldn't want to suggest that currently SafeWork doesn't. The absence of a Code of Practice does not mean that SafeWork is not out there looking at these issues as part of a proactive compliance activity, as well as when we receive safety complaints. I think as well, the committee has heard evidence that reporting some of these matters can be an issue, and that's certainly an issue for SafeWork as well. So a lot of our activity, both from a compliance perspective, is also working with local communities around the ability to report, the ability to feel comfortable to report, to have different reporting mechanisms. So certainly part of our proactive work already looks at, particularly in the agriculture and the construction sectors, but absolutely the Code of Practice will then give, I guess, more detail and more awareness for organisations, because typically when a Code of Practice is being developed and then is implemented, there's a lot of awareness and education activity that goes with it. So it's got that sort of dual focus, and then obviously our inspectors then do the compliance activity on the back of that.
Thanks, Dr. Casey. I think I'll pass now to the Deputy Chair, Ms. Leong.
Thank you, Chair, and thank you, Minister, and thank you all for being here. I appreciate that there was a process in place and that federal process is stalled, and I respect that that's how we've got to this situation. I guess the level of urgency with which we have informally raised this with you, based on the evidence we have heard, now the idea that we're working on a Code of Practice that will have some level of enforcement, but will not necessarily have the resourcing and capacity to be able to kind of hold all of these dodgy labour hire firms to account. I guess my concern is that there's a lack of recognition of the imminent and real risk happening to people right now. The Fair Work Ombudsman's report found that 83% of labour hire companies in the Riverina and 74% in Coffs Harbour and Grafton were non-compliant with existing relevant industrial relations rules. So I guess while it all is well and good to the idea of having a Code of Practice being developed, there are existing industrial relation rules, there are existing legislative protections for workers that are not being complied with. And we have heard direct evidence to say that New South Wales is being seen as a soft touch because we do not have our own scheme. Why can we not immediately introduce a mutual recognition scheme to at least allow or prevent the dodgy labour hire firms that have been rejected in other states from setting up shop in New South Wales as a basic starting point? I'm not saying that all these other things aren't good. I'm not saying we don't have to work through this, but there is nothing stopping us this week in Parliament having some kind of legislation put through that would have a mutual recognition scheme to at least send a message to say that those dodgy labour hire companies cannot open up shop across the border in New South Wales, because currently that is what the evidence we have heard they are doing, and that is hugely a risk for this state, but also for the people who are here.
Yeah. And Deputy Chair, completely agree with you in terms of the urgency of this situation. That's why we've invested $127 million to SafeWork over the next 4 years. So part of the work that Dr. Casey has outlined in terms of the enforceability of these codes of practice that we put through the Parliament last year, and I know with your support. So we are directing resources, additional resources, in terms of going out, particularly in those areas where we're running campaigns and blitzes. I know that there are some coming up. I understand that I'm not at liberty to say where and how because of the sensitivity of the issues, but there are joint collaborative programs of getting out there and running these campaign blitzes. That's one part of it. In terms of, I just wanted to, mutual recognition.
Yeah.
Can I? Yes. We're currently exploring MOU or agreements between the states, so between Queensland and Victoria. We're currently undertaking that work. I hear the urgency in terms of mutual recognition. If I can ask Mr. Galvin or Ms. Rizzo, either of you, to talk about the mutual recognition or
Yep. Who would like to?
or agreements
Ms.
between
Rizzo?
the states.
So there are some legal complexities around the implementation of a mutual recognition scheme that we are working through. Fundamentally, a mutual recognition scheme does require an existing framework, a licensing scheme of sorts to exist before steps taken in another jurisdiction are either recognised here or not. So there are some complexities that we're working through and that will require some legislative amendment or some legislation to be enacted.
Yeah. And I guess what I'm
Yes.
wondering is, given the time frame from when we have heard, and obviously this is an issue that Unions New South Wales and others have been working on for a very long time. It's not new news. The Anti-Slavery Commission has raised it. But I guess in terms of the work of this committee, we've had direct evidence come to us that dodgy labour hire firms are opening up in New South Wales because we do not have a scheme. That is of a level of urgency that has been raised now over many months with the government. I appreciate that there's a lot of reforms that need to be done as a result of what happened under the last government, but this is a current practice that is happening now, and I guess there's been no indication, even in terms of public commentary, to say that New South Wales is going to move urgently to enact a mutual recognition scheme, which might even prevent those labour hire companies bothering to set up shop across the border because they know they're about to be prevented. I appreciate it would need legislative change, but that legislation is not forthcoming as far as I understand. And I guess I'm wondering why there is a delay given the level of risk.
So not wanting to preempt any decision of government, but there's a weighing up exercise that you either implement the mutual recognition scheme, but then it requires almost the same steps as implementing a substantive labour hire regulation scheme in terms of the consultation, the legislative framework that it would require. So we're actively weighing up those options to be able to provide advice to government.
But I guess what I'm saying is, in the interim, I appreciate that there's a genuine question of actually does the amount of work needed to set up a mutual recognition scheme, to draft the legislation and to work on that, could be the same as setting up a regulation scheme.
Precisely.
I agree.
Yep.
I agree. But what I'm wondering is, why has there been no progress on this over such a significant period of time?
Look, I can respond to that, and it's because we've been relying, we made a commitment with the federal government, and the other states pulled out late last year. So this is why, it was late October, it was the end of October, and we're in March, so it's been the last 4 months. I know that we've spoken to the committee and we've spoken to members last year about the urgency, and we were saying we're working with the feds, we're working on a scheme, but I was pretty angry and annoyed that we've gone through 18 months of work and then they pull out, and then the two states and the territory pull out. So we're going back to having, what can we do now? What's tangible now?
But can I just follow up on that? And obviously, I've never had the benefit of being involved from a ministerial level in discussions about trying to create a national scheme through legislation in different states that's the same. Presumably, in that 18 months, work was done.
There was work done for a federal harmonised scheme.
So what I'm saying is, if there's work done on some kind of federal harmonisation that would involve us having to pass legislation in New South Wales, presumably at a federal level or in New South Wales, there is that work done. So actually we're not starting from scratch in the sense of needing to start establishing that. We could take that work and turn it into legislation that could be passed urgently.
So the work...
So that work
Point
and
of
that
order.
consultation
Point of order.
has been done.
Point of
Yes,
order.
please.
I think that the Minister is entitled to respond to what is a question at a time, as opposed to a whole stream of propositions being put. So,
Thanks, Mr. Donnelly. I think the
sure.
Minister would like to.
Yeah,
No,
of
no,
course.
have an
No, I
opportunity
just
now to
Minister, that
respond.
wasn't the case. It was
No,
more
no,
just
I understand
trying to get,
no, I understand the frustration. There was a pretty big debate between Victoria and Queensland because neither of them wanted to give up their scheme, right? So I don't want to reveal anything that was in these meetings.
yeah.
So that was that background. So New South Wales proposed, okay, well then go back. We propose this as a new government. Go back, do some work, but we need to have one host state, and we all need to get on board and we all need to get on with it. Now, there was, battle between the states. Anyway, there was a landing, and so we were, New South Wales were working towards that harmonised process. I think it was going to be Victoria. Victoria was going to be the host, and we were going to work with them and whatever. So anyway, it's all kind of fallen apart, but they're still doing work. But I don't want to, federally and with our officials, work is still happening. But I'm not deluded, and I know that the committee's expectation, the Labor Party, Labor members' expectation, is that we need to get on with it, and union members. So what I'm doing is looking at what are some of the tangible actions now. So the campaign blitzes, working together in collaboration. So Fair Work Ombudsman and Safe Work are about to sign an MOU in doing joint partnerships. The Migrant Workers Centre that the government funded, Migrant Workers Centre, so they funded this a couple of years ago. They're going to open it in the next few months. They'll let all of us know, and this is targeted campaigns. The government provided, I think, 6.5 over 4 years, and this is education and training to stop exploitation of migrant workers in New South Wales, Multicultural New South Wales, Safe Work New South Wales.
Yep.
So that is going to be your tangible action, where their work is to do that, is to do targeting work around gathering the intelligence. So there'll be funding of officers. It's in partnership, their current Visa Assist partnership. So they do have a partnership. Sorry, I apologise.
No, it's all right.
There is a name. They're working together with another partner. Unions New South Wales have a partner, and they're working together with our agents, those two agencies, to make sure that so Safe Work is funding part of it. Multicultural New South Wales is the lead. And I understand that in mid-year there will be more, they're going to launch it and have a targeted program.
Thanks, Minister. I think we might
Sorry.
move to Dr. Kane
Thank you.
for the next questions at this point. Thank
And
you.
can I just say before we wrap up, they all sound like really important good things. So I think that just to acknowledge there's no critique of the work that is being done. It's what else we could be doing. So I just want to acknowledge that on the record.
I get it.
Thanks, Ms.
No, I
Leon.
get it.
Thank you all for appearing. Nice to see you all again. Ms. Casey, Dr. Casey, I have a couple of questions for you. It's my memory of the WHS Act that it doesn't explicitly refer to conditions of modern slavery. Is that correct?
I think that's correct, but if it's not, I'll come back on record and correct that, but that's my understanding too.
Okay,
Yeah.
so it doesn't refer to modern slavery. So when inspections, blitzes are taking place, the inspectors obviously can only do what's within the remit of the
Absolutely.
Act. So there would be other markers of modern slavery which don't then feature in the WHS Act. Now, I know the WHS Act is meant to be harmonised, but I wondered, might it be an idea that we consider amending the Act
Good idea.
to insert the term and look for whatever it is. The drafters will put something together so that you're expressly looking for the markers of modern slavery in addition to all of the other list of things you have to look at.
I mean, what I would say in terms of the general duty or the primary duty under the work health and safety legislation is quite broad in terms of PCBUs having to provide a safe workplace and the welfare of their workers. So certainly when we're out doing any activity, whether it's reactive or proactive, we are looking at, accommodation where it falls under the jurisdiction, where the employer is providing that accommodation. You would look at amenities, fatigue, so how work is organised, how the workday is organised. Certainly psychosocial hazards is also another important component of the Work Health and Safety Act now. So it is quite broad in terms of what our inspectors need to consider in terms of compliance with the legislation. But absolutely, it doesn't look at like wage conditions, those other sorts of things which fall outside the jurisdiction of the Work Health and Safety.
And they wouldn't be then asking questions about whether travel documents had been confiscated?
Not in relation to, industrial relations matters, but if there was travel logs and other things where we were looking at issues of fatigue or work overload.
Not sort of passports, etc.
No, absolutely not. And I guess that's where the work that the Minister mentioned that we're doing with the Department of Home Affairs is really important, and the Fair Work Ombudsman. We're starting to get a bit more sophisticated how we work together on that and target our compliance so that we're doing that and we're looking at it under the Work Health and Safety legislation, but we've got the other regulatory agencies looking at what's the jurisdiction under their legislation as well.
So does that mean that inspectors are trained to be able to look at, to identify those other markers, or they're trained simply with what's, I'm not suggesting they're not well trained, but that they're looking at those things under the Act that they can, or have they had training in, if you see these things, these are markers?
Look, our inspectors are trained obviously under the Work Health and Safety legislation, but as I said, those things are pretty broad, and particularly now that we've got the psychosocial legislation, there's not that much that doesn't come under, that you consider a psychosocial hazard, so the training is certainly encompassing that. But I think the important thing is that their remit, as you're pointing out, is under the Work Health and Safety legislation, so working alongside other regulatory bodies who have that jurisdiction and that specific training is really important.
I guess one of the things that I'm reflecting on is that we've had evidence from the Anti-Slavery Commissioner, and a lot of the work that he's been doing has been about training various parts of the public sector, specifically in modern slavery. So I wonder if Minister may be considering some inclusion in the Act of modern slavery, but maybe also considering some of the existing programs that the Anti-Slavery Commissioner already has for training public service might also be worth considering.
Dr. Kane, I think it's a good idea, but obviously I have to get advice
from
our officials.
Just suggestions, throwing around some suggestions.
But I think that, and I might ask Dr. Casey, so we've got the regulatory program around, so for amenities, for example. So when our inspectors go out, particularly on work sites, as we all know, there is not, there's still, in 2026, we have no equity in terms of female amenities on work sites, not just building sites, but other sites. So I know all of you have had delegations who've come to see you about amenities. Now, our inspectors will go in, they've got a checklist, and now we've added amenities. Amenities has been there, but we're really more pronounced. And so we could have a look at doing something like that through the regulation in terms of accommodation.
We actually have a code of practice specifically on accommodation, and it's just been renewed, so updated, and it does now contain I guess some more detail, particularly targeted at the rural accommodation, which can be quite specific. So there are specific codes of practice in addition to what you're talking about, Minister, around the amenities. And then going back to the earlier conversation, they become mandatory on 1 July. So that's another, I guess, tool.
Why don't we work with you? Why don't we work
Okay.
with you or the in collaboration with the committee?
I mean, I think there are offences related to modern slavery. You've got actually a mechanism here by which the state can get involved and recognise it. I think having it linked to the Work Health and Safety Act would be quite an important mechanism for getting some action here, and would link with the proposed code of practice. So I think that's where you're going,
Yeah, no, happy
Dr.
to.
Kane.
I think if we can chat.
we can have absolutely, we can take it away and look at it and get our legal people to have a look at it. And I'm very open. I think that's a very good idea. And sorry, I didn't mention, but there's some really good work around the collaboration with Home Affairs as well, as you were saying. So I thought that was great as well. So where you're looking at safe work, Home Affairs, Fair Work Ombudsman, working in collaboration. So everyone knows their jurisdiction, what they have to do, but to the point around passports and things like that, we've got, Home Affairs and obviously the complaints around the PALM scheme and that process. So, but that's a very good idea.
Okay.
And let's get back. Yep.
Thanks,
Can
Minister.
I just jump in with
Oh.
one other thing just to insert on that, which is
I just want to follow up on that.
Oh,
first,
sorry, you
if
follow up and
that's
then
And
okay.
I know
Yeah.
Mr. McDonald also will have some questions. So
And so have I, but
and
appreciate
Mr.
the time.
I'll just follow up with one, which very quick. Is it possible for us to have on notice those codes of conduct and things that you were talking about? I mean, they might already be publicly available, but if not, it would be great to have a look at those as well if we couldn't, Dr. Casey.
Yes.
Thank you.
Okay. And can I
You can
can
go
I go to
Mr.
Mrs.
Donnelly and then
Okay.
I'll do mine as supplementary. If that's,
Okay.
yeah.
And
Oh, thank you.
I'll
Through
go
you,
to you,
Chair.
Mr. Donnelly.
Thank you, and thank you, Minister and officials for coming along today. And can I acknowledge the work that's been done and the challenges that have been presented, very real challenges arising from the collapse of what we hoped was going to be a very solid national approach, and requiring us now to sort of carve our own way forward in dealing with it. And thank the officers particularly for what is, in a sense, creative work they now have to do to look to see what New South Wales will do to move things along. But my question, Minister, is to the matter of the compliance work that has been being done, and particularly in the context of the supply chain compliance. So, just on the matter of supply chain compliance, and listen, if you need to take on notice in light of the time, there's only effectively a couple of minutes left.
No, that's okay.
But
This
the
is-
supply chain compliance program is obviously being done. It is formalised, I presume, in documents, and it has been
Sorry, I've
issued
just found it.
by inspectors and others driving into these areas of really what is nothing short of exploitation of workers. So, supply chain compliance program update, but if you need more time because you've effectively got 120 seconds, maybe take it on notice.
I'll give you, so thank you very much, Mr. Donnelly. I know that you're very passionate about this area and been a very strong advocate. There are two things here, and I know that Dr. Kane knows this area, ethical clothing trades extended responsibility scheme, very well. I haven't mentioned it, but I just wanted to let you know that the inspectorate in the Premier's department is doing some really important work to enliven it, and I think we're getting to August, Ms. Rizzo.
Yes, that's right.
So we'll have a lot more to say, but I want to thank you all for, and particularly Dr. Kane, for pushing us on this. That's very important. With respect to the construction compliance unit, again, the construction compliance unit based in the industrial relations, the Premier's Department Industrial Relations Inspectorate. So from 1 March, this is a really important initiative where there are 3 complementary streams of work. And so and I know that that the government has done a lot of work with respect to procurement. Dr. Kane, you've been involved in that. Now, prior to government awarding a contract, because this comes up to us all the time, that you award a contract and then you've got the 3rd, 4th, 5th tier that's not following, whether it's entitlements, whether it's long service leave, whether it's not paying the super, so not paying their tax. and then the main contractor says it's not our responsibility, we're doing what we have to do by government. So the CCU, the Construction Compliance Unit, will conduct checks of publicly available records held by relevant regulators, and a report of any findings will be provided to the procuring agency to support its due diligence process. So there's going to be a lot more due diligence around awarding a contract, a government contract. And what that has done, can I just say, and through our agency and Ms. Rizzo's team, is working very, very hard, speaking to the contractors, speaking to the agencies, saying we'll do this work. We've sent a signal, a very strong signal out to the market that we're not going to take their crap. That we want them. They want a government contract. They have to follow the rules, and everybody else has to follow the rules under them. The CCU will work with the client agencies and head contractors to develop and maintain a database of subcontractors operating on New South Wales construction sites, improving transparency and oversight. And what that does, so we've got that body of work, that data, that will give all the agencies, will give government and the public an opportunity to see, right, who's a subby working on a government contract. And this sort of falls into my space as well around we've got the administration into the CFMEU and all, the things that we've heard with respect to what they've been doing. We want to make sure that this industry in particular is rid of criminals and corruption all across the industry. So moving on these dodgies and having these subcontractors in particular, not only getting government work, but all work to do the right thing by workers, working conditions. And just finally, the CCU will conduct audits of head contractors and subcontractors to assess compliance with industrial relations obligations, including super, payment of wages, and we'll continue to work with the existing contractors. I haven't had any pushback from any of these tier ones. I don't know.
No.
They've been, I've had, pushback on other things, but it seems that it's the signals out there.
Sure.
And so I just wanted to report
Thank you
that
for
to the
that.
committee.
Thank you.
We are at time. Minister, importantly, the new codes of practice, the Safe Work Codes of Practice, which can be enforced from July.
Yes.
So what is the timeline on the development of that in relation to this in particular? Because that's the urgent,
Yes.
that you've indicated that is the point
Yes.
which we can act now to get some control of what's happening. So what is the timeline around it? Can we expect that this year?
Yes, you can expect it this year. Well, okay. We're trying, we're working.
Certainly the work internally within Safe Work has commenced, having recently received the approval from the Minister. Typically the codes can take 12 to 18 months. But that's because we're doing that consultation. So while we're doing that, there is an important awareness component that we can still work on. And as I said, the compliance activity and the broad duties under the Work Health and Safety Act means that we're not doing anything while the codes develop, Dr. McGurr. So I think that's just an important point. But they do take about 12 to 18 months.
And to Dr. Casey's point, when we passed the legislation last year around the mandating codes of practice, we still haven't switched it on in the Parliament. We still haven't switched that part of it on in the Act because we told everyone it's going to take 12 to 18 months, doing all the consultation, the workshops. It's a lot of work, a lot of detailed work with the industry and the unions. With respect to this one, Dr. McGurr, I understand the urgency.
Yep.
I hear you, we hear you. And I know that the industry, I don't think that we will have, I'm not talking for the industry, but the industry players that have come to see us, and I'm sure they're the same that have come to see you and report to you, is that they want urgency as well.
Yep.
So the industry, the NGOs, the unions, everybody's all on one side in terms of getting this right, level playing field, and making sure that the good operators that do the right thing are not out of existence. So I hear what you're saying.
Yep. And that's certainly that's the work we've done
Yeah.
over the last 12 months indicates this is the one thing everyone agrees on and also agrees on the urgency. So thank you, Minister. All right, thank you all for your evidence. The Secretariat will contact you in relation to any questions or supplementary questions on those, and I understand you'd be happy to answer those. I want to thank you all for appearing, including Mr. Galvin. I'm sorry that you didn't have an opportunity, sir, to participate. Thank you for your attendance. And
We'll throw you lots of supplementary questions through the Minister.
Next time, maybe.
Okay, and so we'll
Thank
call
you.
that, we'll bring that part of the public hearing to a close now. Thank you
Great.
very much.
Thank you.
Thank you.
New South Wales Parliament Committee on Modern Slavery. Thank you very much for agreeing to come at very short notice, but we very much appreciate it. And not only at short notice, but I think you've actually sent through a presentation, which extraordinary, actually. So thank you. Above and beyond.
You're welcome.
Thank you. And is it Mr. Dargaville? Is that...
I don't mind what I'm called, so long as it's not late for dinner. It's normally pronounced Dargaville.
Dargaville, Mr. Dargaville. Thank you very much, Mr. Dargaville. Okay. Now, thank you. As I said, thank you for coming. I'll get you to, if you don't mind, get you to be sworn in, to take an oath, please. And I think we sent the words to you, but
Correct.
You can take either the oath or the affirmation.
I'll take the oath.
Okay.
I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thanks, Mr. Dargaville. All right. Now, you've sent through a presentation, and generally speaking, we would say to a witness, restrict your opening statement to 2 or 3 minutes. But in fact, actually, we've had a chat this morning, and we'd actually like you to give us your presentation. So the context for us is, I'm sure you're aware of this, but just to recap, the context is the committee has been very concerned about the lack of labour hire regulation in New South Wales, and we've made representations to the government, and in fact the Minister attended this morning a formal public hearing on the issue. There's clearly been an issue with harmonising labour law regulation at a national level. That process has broken down. The New South Wales government, having done some work, tells us they're now embarking on a regime within New South Wales. The evidence this morning was, essentially it would almost take as long to do mutual recognition as it would be to establish a separate scheme, but they're working on that. And they've indicated to us that in the meantime, they are going to introduce a code of practice under safe work, under our work health and safety legislation that will be enforceable as a sort of measure in the interim. Still, that will be taking some time. So in that context, we remain concerned at the lack of labour hire regulation. So we're very keen to hear about how Victoria has approached that, and happy for you to do the presentation. But I guess the specific context for the committee is what can the government do outside of formal legislation for labour hire regulation to improve the situation in terms of people acting as labour hire firms. In other words, without specific legislation, what can be done? What have you done? So that's a lot of subtext question. So on that note, I might hand over to you, and thank you again.
Thank you very much for the opportunity. I welcome the opportunity and am grateful for it, and think that the work of the committee is very important. I'm very pleased to be given the opportunity to address your work. So just a quick snapshot of what we do in Victoria and why. There was an inquiry into the labour hire industry and insecure work that was concluded in 2018. It was a major inquiry. It attracted a lot of interest and a lot of participation by employer associations, labour hire providers, host users of labour hire, non-government organisations, churches. There was a lot of interest in it. It concluded that that there needed to be a barrier to entry regulator to deal with labour hire. The inquiry conclusions are not dissimilar to many other inquiries that have happened prior to it and since it, including the Harvest Trail inquiry, which was supported by some very significant Commonwealth agencies, including the Fair Work Ombudsman, the Australian Taxation Office and others. So the objects of our Act is to protect workers from exploitation by labour hire providers and the users of labour hire services, and to improve the integrity and transparency of the labour hire industry. A lot of labour hire services are often orchestrated through quite opaque vertical supply chains, and so by improving the integrity and transparency of the industry, that is one of the foundation requirements to ensure that workers are protected from exploitation, and it is temporary migrant workers that are so often exploited in the labour hire industry. So the obligations under the Act in Victoria is that all labour hire service providers must have a licence, and host users of labour hire services must only use licensed providers. We provision a public register. It's very easy for hosts to ensure that they're only using licensed labour hire providers. There are consequences for not using licensed providers, and there are consequences for providing unlicensed labour hire services, and that can be penalties of over $650,000 for a corporation and over $160,000 for a individual, for a natural person. One of the inquiry recommendations was that the cost of breaching laws should not just be part of the cost of doing business, that there had to be a meaningful a meaningful set of interventions to ensure that there was actual behaviour change.
Mr. Dargable, I've just noticed we've been joined. So in the room here there are 3 other members of the committee, but we've just been joined online by Ms. Leong, the Deputy Chair. Just so you're aware, you would see that come up on the screen. Thank you.
So that's the theory, and then the next slide, which I provided the committee, and I think your secretariat said I shouldn't share my screen because it might break something. So I'm just hoping that the committee can.
We've got the presentation, yes, and we're following it. Thank you.
So that's the kind of theory of it, and then in firstly going to the horticultural industry, you'll see that our licensing data to February this year is that we are dealing with presently 448 entities supplying labour hire services into the horticultural industry. But that is after we've refused 198 businesses their application to provide services, and we've cancelled 259 labour hire providers in the industry. So the total number of participants providing labour hire services in the horticultural industry in Victoria is half than it otherwise would have been were it not for a barrier to entry regulator. Our Act was recently amended at the end of last year, and the fit and proper person test has been strengthened, and I expect that the total number of labour hire providers in the horticultural industry and some other industries, including the construction industry, will compact further as a result of those more stringent requirements which have been carried by the Victorian Parliament. In the last financial year, if you go to the next slide, what a snapshot looks like for a single year as opposed to a whole industry over our journey. In a single year, last year we counselled 535 providers, we finalised 330 odd investigations, we refused 100 applications and imposed specific conditions for performance on a further 48 businesses. And sometimes a business may be, we think that it's not really at the point that they should be remove permission to operate, but there is sufficient concern to impose a specific compliance condition. So, for example, you might have a business that has been supplying workers on the pretext that they're independent subcontractors, whereas they're actually employees, and not paying them the award and superannuation's not being honoured. And so what might have happened is that business is in some circumstances, they will have had a condition that they can only provide labour hire services in respect of employees where there is traceable means on remuneration and that sort of thing. In other cases, we've cancelled licences where it was clearly an avoidance device and there was no confidence that compliance would proceed from the decision. So there is a range of tools which can be used flexibly and proportionately is the key here. And the key also, I guess, I'm inviting the committee to consider from this evidence is that it is a fairly active regulator. It's quite a dynamic register, and there's a lot going on in the labour hire world. Now, in our journey, we have had, of course, providers that are not necessarily based in Victoria but are supplying labour hire services within Victoria, but have been involved in comprehensive avoidance structures such as proxy directors. Someone might have come to Australia on a student visa. They've created a constitutional corporation here, created a director ID, a bank account, taken out a mobile phone number, and then they've returned to country of origin after being here for maybe a month, and then apparently are conducting an active labour hire service business in a regional location in Australia. Now, one interpretation of those facts might be that that's actually what's occurring. An alternative explanation is it's a fake company with a front director which is being controlled by other principals. And so we have an intelligence and analytics unit. We're a cost recovery regulator, so we're not going to government asking for funds after the initial startup commencement cost of the agency. There is no call on the taxpayer to run the agency. It is labour hire firms pay a licence fee that's retained into a trust account by the authority. That's what funds our operations. So we're a bit different to other labour hire regulators in other jurisdictions, and as a consequence, we're larger. One of the byproducts of being a bit larger is we have a dedicated intelligence and analytics unit, which assists us with our work. And so in looking at some of those phoenixing structures or sophisticated avoidance structures, we have identified a number of actors that are actually based in New South Wales, but the avoidance structure is being represented here. And we've seen evidence of modern slavery, systemic avoidance behaviour by taxation law, occupational and safety law, migration law, the award being abused. And so we've had occasion to map those avoidance structures, because as they turn up in Victoria, we've got to have awareness about their association. So if I take you to the next slide, you'll see one example of one part of an avoidance structure operating in New South Wales, where the authorities needed to treat various entities in that corner of that particular syndicate, where a range of entities are turning up seeking a permission to provide labour hire services, or who have managed to get a permission, but we're weeding out of the garden, as it were. And so often they've got professional enablers that are creating the avoidance structure. And then if you go to the next page, that zooms out to the entirety of the structure. I'm not, for various legal reasons, able to share with you the identities of the parties involved and the nature of the transactions, but to give you a visual insight into what a single avoidance structure operating in New South Wales looks like. And what's particularly interesting is, or what I hope you'll understand is interesting, is that different primary agencies will apprehend elements of that syndicate. So you may have Waterforce that will see some abuse of Australia's migration system in certain elements of the system. The Australian Taxation Office will most certainly see non-remittance in other aspects, or phoenixing behaviour. The phoenixing task force will see elements of it because there are entities being created, tax not remitted, wages not remitted, super not remitted, and then the entity's put into administration and everyone's left high and dry. Trading creditors are harmed. And then the giggle just keeps continuing, where the principals have a different proxy to orchestrate the same set of harms in the same community, often involving the same victims. But then you'll also see the occupational and safety regulator dealing with another element of the piece. And if we're looking at it through the prism of modern slavery, you'll see modern slavery appear or being manifest from certain aspects of this syndicate. And the key point that I'm hoping to convey here is that tackling modern slavery in isolation of understanding the overall integrity challenge to government is something that's you need to have a single lens to the problem that apprehends the dynamic, and then is got the power to not only interfere with it but to dismantle it. Now, in Victoria, we can interfere with it and stop this particular syndicate's presentation in the jurisdiction of Victoria. We can't mobilise, obviously, in New South Wales. That's not our job. Wouldn't be proper for us to seek to do that. We don't have the power to do it. But it's what I'm trying to convey here is that some of these structures are quite sophisticated. They're very large. They have an enormous impact in terms of harms, but they're understood through different lenses, and different elements of the problem are understood by different primary agencies. And so then to the last little slide here, which is having shared that those set of observations, the key point here is that modern slavery in isolation without understanding the dynamics that create the problem, the treatment of the problem needs to apprehend the totality of the structure. The Commonwealth committed to implement a national approach. There was a very compelling set of reasons to do that, either a national approach or they committed to implement their own approach. There's been various versions of that over the years, but that clearly hasn't happened and is not likely to happen. So that leaves the states and territories with the original problem that needs to be tackled. What I would say is that the labour hire licensing scheme provides the necessary single lens to be able to apprehend the harms across various domains and tackle at least the supply side of the problem. There are two elements to this. You've got to tackle the syndicates and the normal sort of non-compliance that happens in the labour hire industry, and there's also got to be an effort at the demand side of the problem, which is about saying to large hosts, well, look, it's not the right thing to be entering into sub-price contracting that is creating a market demand for this kind of activity. The cost to government to setting it up is, it's a one-off establishment cost. The Victorian government funded the establishment of the Victorian Labour Hire Authority, and after it was established, it has not cost the Victorian government funds. As I say, we're self-funded. There's been a good return on investment to Victoria in the sense that there has been a reduction in the amount of abuse of the taxation system that accrues to the labour hire industry. There's been a good return to the community in the sense that honest businesses that are seeking to compete on a level playing field have less static in competing with underquotas that are racing to the bottom of which they never find the bottom, it turns out. My evidence is not that we've solved all the problems, and we've got a lot more work to do, and we certainly are looking forward to those amendments coming online once they're proclaimed and pursuing our mission. But it is my evidence that I think it is a positive result for the community and for government ultimately. And whilst it's a contested debate in parts, there are certainly aspects of the labour hire industry that have been quite pleased with a journey to levelling the playing field that otherwise was completely out of control previously. Thank you.
Thank you. And thank you for that presentation, which I have to say actually broadens the significance of the labour hire issue for me. I guess I'd seen it pretty much in isolation, but I think what you're saying is that you're really dealing with organisations that are very clever in the way they are constructed, so that they operate, and if they break the law in one area, tax or some compliance, and I think you mentioned in relation, I don't know, to water, for example, they are able to deal with that agency in a way that doesn't affect the rest of the company, because the agency can't see the rest of the company, and the company is actually so complex in its structure that that agency may not even be aware of the links to other parts of the organisation. That's quite a profound insight, and what goes with that from what you've said is that this lens of modern slavery, labour hire and lens together would actually enable the government to get a sense of what's going on with those organisations in the broader scope, which they can't as an individual agency. So the modern slavery lens actually provides a useful way of tackling what's a major concern. So my question, though, is it seemed from your evidence that you were saying that companies with these complex structures continue to operate in New South Wales. If they try and do anything in Victoria, you can get onto them. You've got an analysis, you've got a team, you've got a structure. But in New South Wales, none of that exists. And then they use the base in New South Wales perhaps to try and get back into Victoria from time to time. Do they?
That is certainly what's been going on with this particular syndicate and some other syndicates. Correct.
And I guess the same would be true of Queensland, perhaps, although I guess that's speculation. So it actually represents an issue for Victoria that New South Wales is, in a sense, allowing these firms to operate.
I'd put it through the prism that it represents a problem for the country. These are avoidance structures that are looking for getting around the nooks and crannies of the regulatory architecture, whether that architecture is orchestrated federally or within a particular jurisdiction. And it's not a criticism of any particular jurisdiction at all. It's just that there is a market demand for it, and that market is going to be served, and there needs to be a strong regulatory focus on dealing with it. Certainly we see it represented as it comes into Victoria. I'm not suggesting for a moment that we've solved all of the problems in Victoria. We haven't. But we think that we're part of the solution. A lot of the entities that we have removed from the marketplace, they'll often have a website with a value statement. So your earlier question, Chair, was, what of self-regulation, or what of codes of practice as a perhaps a bus stop towards a more serious program. There really are quite a lot of entities that will say all the things you want them to say. They'll have a value statement. They'll have statements that often generated by generative AI these days about how they're ensuring compliance, how they've got internal codes of practices on a desk audit basis. You look at them at first blush, it looks all very lovely. And then you get on site and you see some financial intelligence and some other inputs, and then you realise that that's all just nonsense, and you've got to deal with people on what they do rather than what they say. And this is a notoriously difficult industry to deal with on the premise that it's a code of practice type thing, because these are structures that are set up to avoid the system. They're not there to do anything other than make money for the principals, and they are involved in substantial and widespread law breaking across, local government, state government, and Commonwealth law. It's hard to apprehend how a self-regulation guidance sort of system motivates change of behaviour with those sort of actors.
Look, I think, to be fair, the code of practice would be in the context of some changes to legislation here that would make it enforceable, and I think there was an intention that there would be safe work inspectors who would be out policing that code of practice. So it wasn't, to be fair, not self-regulation. I think there was an intention to have boots on the ground. I guess, however, the point that comes home to me is that that's going to be from a safe work lens. And these organisations are much more complex than that. And it may be that we'll still miss the boat on how they operate, just having that purely that safe work directorate looking at it without looking at a whole range of other issues, which is actually quite helpful. I just going to check if there are any other questions from the committee. And I know, Jenny, you're online, but Ms. Dr. Kane, I've got another question, or Mr. Donnelly?
Yeah, thank you. And so thank you, Commissioner, for joining us today. It's great that you could join us, and thank you very much for your presentation and the opportunity to ask you some questions. Are you able to provide to the committee a sense of how profitable this labour hire industry is in terms of its money-making capacity? Obviously, it's a relatively straightforward model in some sense, and as you've described, tragically, it's, and I think using the words you quoted, it's a race to the bottom where there's no bottom at all. So in terms of looking at the way the labour hire industry was operating pre-legislation and regulatory influence, it was presumably much more profitable then and it's become less profitable, or is it still quite profitable now to the extent that they can hide behind these complex structures?
Regrettably, there's a lot of money being made by principals who are operating these structures. That is the sort of black economy actors. We're talking about avoidance syndicates that are pulling in not tens of millions but hundreds of millions of dollars.
Wow.
The Phoenix Task Force have had various goes at trying to estimate just what the phoenixing element of labour hire is costing simply government in revenue.
Yeah.
So that's a subset of a subset of a subset, right? And estimates range between $1 to $5 billion per annum.
In the state of Victoria?
No, nationally.
Nationally, yep.
Right. So at the upper range of $5 billion per annum in revenue.
Yeah.
Which is just the Phoenix subset of the problem, or let's take the much more conservative estimate of $1 billion per annum in government revenue for the state of New South Wales. That is taxation avoidance, but as it represents to the workforce, it's clearly a bigger number than that because wages are supposed to be bigger than taxes, and then the harm to all the legitimate businesses who are trying to do the right thing, who are being underquoted and not winning work. There's certainly some publicly available products for the community to consider from the Black Economy Task Force and the Phoenix Task Force, and I'm sure the Secretariat could provide you with better numbers from those, at least the publicly available material that's available to the committee. But some of these structures are pulling in just gobsmacking amounts of money and getting away with, quite offensive behaviour. It's not a marginal small problem.
No, it's not pocket change. And just my final question before I pass back to the chair. You helpfully in the early part of the opening statement referred to the agencies involved, and specifically ATO, Border Force. You've got obviously WorkSafe. Then obviously there's the modern slavery framework through legislation. I presume fitting into that there is also at least some occasions where both the Australian Federal Police and the Victorian Police Force.
Certainly, we do a lot of work with Victoria Police, the AFP. There's lots of agencies we work with. So that the premise is that a labour hire provider has to comply with a range of legal obligations:
Yes.
tax law, migration law, workplace law, accommodation standards, transport standards, workers' compensation, so on and so forth. So all of the normal sorts of obligations which attach to employing people and supplying services attached to a labour hire company, and the premise is you've got to follow all the rules. Now,
Of course.
if you don't follow the rules and you're doing the wrong thing on health and safety, or if you're doing the wrong thing on the Fair Work Act or taxation law, then you run into trouble with your labour hire licence, is the concept. So, of course, we work with as many agencies as we can. We do quite a bit with law enforcement in the construction industry in Victoria. There's been a lot of work with the Victoria Police. They've been fantastically supportive through the Hawk Task Force, and also with the AFP through the JORG. And then also in relation to modern slavery matters, we deal with the AFP. The AFP does some wonderful work, but the size of the problem is bigger than what I suspect they can allocate resources to. So the threshold for them to be able to invest in intervention is never going to be enough.
No.
That's why you need a barrier to entry, because when you see an agency have a very high threshold, it's suggestive that the problem's bigger than the resourcing commitment can furnish. So we've been very pleased to work on some of those modern slavery matters where we've been able to affect treatment of the problem. Of course, refer to the AFP in the event that they're able to take enforcement action. But ultimately, it's about ensuring that the wrongdoers aren't in the marketplace in the first place and the victims are squared away.
Okay.
Thank you, Commissioner.
Thank you. I might go to Ms Leong, who's got a hand up and who's online.
Thank you so much, Chair, and thank you, Commissioner, for joining us today. It's really helpful insights to hear how things are happening in Victoria. I wanted to go to have an understanding of the amount of licences that you've either refused to renew or cancelled or refused the application, say in that example you gave us within the horticultural industry. To what extent would you have information that those labour hire companies would also be operating in other states? And I guess to what extent would there be some form of collaboration that could occur between Victoria and New South Wales in terms of your agency becoming aware of the fact that these labour hire firms that you have either refused an application for or indeed cancelled their licence are also operating in New South Wales? Like, to what extent is that something that could be facilitated as a information share exercise in the absence of New South Wales having a regulatory scheme, recognising that you've said obviously this is a national problem, right? That people are going to work however they can to try and get around it.
As you know, there's a scheme in Queensland, there's a scheme in Victoria, and also the ACT, and a much sort of smaller subset of a scheme in South Australia. So that's a good start. In terms of your information disclosure question, we can disclose to law enforcement agencies or co-agencies, regulators, that kind of thing. So it's a problem for all agencies when like a policy arm of government wants good information, and law enforcement agencies can't give them the granular insights, which is why the sort of broader sort of studies of things like the Harvest Trail Report are important, because that's really the people with access to the raw intelligence telling the story to policymakers. To the precise question, if New South Wales had a agency that was a enforcement agency that was operating in the field, whether or not it was called a labour hire regulator or called something else, then our secrecy provisions of our Act enable us to make disclosures to enforcement agencies. We do nonetheless produce on our website the register, and everyone in the marketplace can download that register and see who's got a licence to operate in Victoria and where they're based, and we provide for a downloadable CVS, so anyone anywhere can download that and have a nice old data party. And you can see from that there's a range of entities that are not licensed to operate in Victoria who are based in New South Wales, and we know that they're operating in New South Wales. So there's publicly available information for agencies if they're so inclined, and if we had a law enforcement agency to disclose that had the remit and the function sufficient for us to do so, we like to collaborate with as many agencies as we can to it's just good for the community and serves the public interest. But we're not in a position to just disclose raw material to a department as such that might be exploring things that doesn't have a particular statutory function.
Is there a role that the Department of Employment and Workplace Relations can play in that? Could there be a function? Because I appreciate, and we're very aware that the national scheme or the attempt to have a national approach to this has really stalled. Is there a way that the Department of Employment Workplace Relations could actually be an agency where the various states disclose to, and that they would be able to hold that? Or does it have to be an agency in the form of a police or AFP style agency?
If New South Wales orchestrated either its own labour hire agency or it created an act that gave the New South Wales Occupational Health and Safety Inspectorate powers and functions to investigate and deal with non-compliance in connection with labour hire, either of, we could certainly make disclosures to either of those alternative agencies in the broad.
Yeah.
But a departmental function that's talking about having codes of practice and industry guidance and all that sort of lovely stuff, which is, speaking to that part of the market that is actually not dead set sort of committed to avoid the law, then there's not much we can do by way of disclosures to those sorts of entities. But certainly if there's an agency that's got an act and is well in powers, then scope under our secrecy provisions is much broader.
Thank you. I'm just conscious that Mrs. McDonald would like to ask a question, if that's okay, Ms. Leong.
Yeah, of course, no problem. Thank you, Chair. I do have one that I'll follow up, but I can do that in a supplementary if that's suitable.
Yep, thank you. We are, yes, that might be the case. Mrs. McDonald.
Thank you, Commissioner, for your time today. I wonder how long has, and I probably should already know this, but how long has the Labour Hire Authority been in existence in Victoria?
So we commenced licensing operations in 2019. That I think was it should have been on my first slide. So the Act was in 2018. We commenced in 2019.
Yep.
We had a 6-month transition window where providers could apply for a licence. I think close to half the industry turned up in the last 48 hours of that transition window.
Okay.
That was a fun 48 hours.
Okay.
So since 2019, and we started fairly small, and it has grown since then.
Yeah. And on the last slide, you've said the Commonwealth committed to either implement a national approach, but it hasn't occurred, and nor is it likely. So that hasn't stopped your organisation from continuing to do what it does. I was just wondering, have you had any input into, say, what happens on are they coming to you for advice, or? guidance?
So there's when the Commonwealth proposed initially in 2018, when the recommendation was to set up a barrier to entry regulation, the Victorian government approached the Commonwealth and suggested a national approach, but at that time was rebuffed. So a number of state jurisdictions proceeded to set up their own schemes. But the posture initially was always, people thought a national approach would be better. Then for a period, I think a former government said they'd set up a national scheme, but that wasn't progressed. Then the current government said they'd set up a national scheme, but then converted it to a national harmonised approach. And then I was involved with a broader working party with officials from across the country in putting together a nationally consistent approach that was achieved inside 6 months, which I'm told is relatively quickly as far as getting states and territories to agree to a single thing. And then it was over to the Commonwealth to fund up the commencement cost, which they didn't get to. And then subsequently Queensland pulled out of the piece and Tasmania pulled out of the piece. So there doesn't appear to be any signs of life to the Commonwealth saying returning back to their commitment to set up their own national scheme, nor does there seem to be any interest in really pursuing a nationally harmonised approach to make sure that we've got a consistent thing across the Commonwealth. And so that's really where I came to my conclusion that it's kind of up to each jurisdiction to figure out how they're going to approach the problem.
It's probably a good idea too, by the sounds of it. And you mentioned that you approach on a cost recovery basis. I just wondered if you could tell us a little bit more about that.
So labour hire providers pay an application fee to be considered for a licence, which is non-refundable. So those avoidance structures that you've seen, they've all had to apply for licences, pay a non-refundable fee, and when they're refused, as they generally are, that's revenue retained by the authority to fund our regulatory operations. And then there's an annual licence fee that's paid by licensees each year. It's not a popular thing. The industry doesn't like having to pay for its own regulation, but it does set the Victorian scheme up a bit uniquely from others in the sense that we don't have to go cap in hand to Treasury asking for a funding round, and all of the monies collected from the industry are used to support regulation in the industry. It's not taxed by stealth. It's not money collected for one purpose that's then going into other government programs.
So, Dr. Kane, final question. Is that
Sorry, just a really quick follow-up. Thank you again for appearing. Just following up from Ms. McDonald's question, often when this kind of regulatory approach is discussed, there's concerns that particularly that kind of licence fee and the cost recovery might price the industry into oblivion, and then you have all the concerns about, but we need the flexibility. You've heard these before. I just wondered when the Commission was starting, when the process was starting, were those arguments put up? And it would appear that there's still a very robust industry for labour hire in Victoria. I just wondered if you could say a little bit about that.
Yeah, of course there was a lot of advocacy around the fee structure, and there was lots of concerns raised by industry that they would have to pay money to government for a thing, or money to an agency for a thing. There is clearly a very strong diversity and there's lots of diversity in the market, so there's no sort of lack of competition in the market, if you like. And those providers that have had to pay fees but are offering a legitimate labour hire services proposition, I think it can be safely said have less competition threat from folks who've been eating their market share to feed a horrible avoidance beast.
Yeah.
So whilst each individual business may resent having to pay a fee when the idea is introduced, over time they can begin to appreciate that in the longer term, it is a much safer position for them to be in the
It
marketplace.
levels the field, I guess. Yeah.
Thank you. Thank you very much, Mr. Doug Abel. That's been very helpful,
Yeah.
I think, for the committee.
Okay.
We appreciate your time, particularly at short notice, and your presentation. And we may have some supplementary questions. I think Ms. Leong indicated she would like to send a supplementary, so I will send that through to you. I hope you'll be able to answer that for us. So on that note, I might bring this hearing to a close, and thank you once again for your participation. Thank the committee.
Thanks, Commissioner.
Thank Hansard.